obvious question, but is patent protection only for commercial use?
Only for, so we'll talk about that a little bit more here in a minute when we get to this idea of brand. No, but there are some different rules that apply depending on the circumstances. Great question. The question for anyone who didn't hear it was, do patent protections only apply to commercial use? And the answer is no, it is a pretty total monopoly, but there are differences in terms of what, like there are some potential exceptions to that, such the rules change under certain contexts, and those contexts are important to understand with patent necrosis. So we'll talk about that in a minute. Yeah.
Can non-US citizens file a patent or like be on a patent, like the co-inventor or somebody?
Yes. Yeah. Yeah, although that does raise another thing that I should have mentioned in passing a minute ago, which is IP protections in any of these areas, patents included, are territorially bounded. All of this stuff only applies in the US. You can file separately for a patent in other countries, but you do need to file in each place where you want the thing to be protected by patent law. Yeah.
How old do you have to be to file a patent?
Good question. You guys have an idea?
Probably like 18.
Nice. What? No, I mean, are you asking because you have inklings of a innovative thing, or just curious? Yeah, no, I don't know.
There's not one.
There are no age limitations on it.
Nice. No age limits. Although, sorry, real quick, one thing that is worth noting there, we'll talk about this in a minute, but you do need to be able to prove that you are the person who conceived, is the phrase conceived of the thing. So I couldn't be like, my 3-year-old is filing a patent. Trust me, he's only capable of that. But yeah, that's interesting. I didn't know that. That's awesome.
So the flip side is it's illegal, like if my daughter came up with an idea, it would be illegal for me to file that patent in my name, because it has to be the true inventor. So,
You said that the patent law can apply to characters in the US. Does the US regulate, like, if someone comes up with a patent and someone in, like, say, Canada mass produce that product, so they import that into the US to try to track it down?
No, so the part of that U.S. patent law would cover is we are now trying to sell this thing in the U.S. Right, so the U.S. could not do it, like we could be, fussy in Canada, but like we couldn't be like, hey, you get to like sue these people or whatever for them like producing and selling it in Canada. But once they're like, we're trying to import this in the U.S., that would be an no. Yeah.
How does that work in terms of like selling online?
In terms of selling online, how do you?
Like, say you're selling a product, like you make it in Canada, and you're selling it like online, people in the US can still buy it.
So the selling it to people in the US part of that is the part that we do. Kind of no matter what the instrumentality is that you're using to facilitate the transaction.
But I guess, like, how would the producer regulate that? Like, would they just go to Amazon and say, like, don't sell this to people in the US? Or would they have to be something separate where they insure themselves?
Where they, what do you mean by
Like,
insurance?
could they use the online retailer as a third party, say like the retailer promises they won't sell in the US, or the producer have to individually independently?
They here being the US government? Like what sorts of
Would the
measures would the
producer
US
have
government
to
take?
independently verify that it's not being sold in the US, or could like Amazon saying we won't sell in the US?
Gotcha. Yeah, no, I mean, if the person has reason to, the entity has reason to believe that somebody's infringing on their patent, they would bring that to the attention of the US government, whose job it is then to enforce that. Either, I don't know enough about the details of that to know which parts of that would fall in the category of like, the executive branch takes some set of enforcement actions versus how much of it is like, handled in court or whatever. My general understanding, Daniel would probably know more about this than I would, but like I would think that most of that I think would be handled through litigation through the court system, and the court could then, in some cases, just be like, here's an injunction, they have to stop doing this thing. If they don't, then they're in trouble. I think that depending on the context of the exam, depending on what the circumstances are, there might be other cases in which they've already done a thing. Like let's say they've been doing it for a while and generated a lot of money, and you could sue them and be like, And the court might be like, you need to pay them all these damages for, like both under the theory that people shouldn't be able to profit from having temporarily violated these laws, but also on the basis that it did harm you to have this competitor in the market that should not have existed. But if the other country, like if a given company were like, we don't care, we're not going to listen to you, and the country that they reside in was like, we've got their back, we're going to also, we are going to back them on not needing to listen to you, then things get more complicated, right? And there are a variety of things that the government might then try to do, get the site taken down, whatever. Or in some cases, more kind of extreme, or kind of like hostile, like more aggressive actions, like other kind of terrorists against a given country or conducting offensive cyber attacks against a country or whatever. So it's like that gets into the bucket of issues that we're concerned about with a country like China, right? Where it's like the government pretty openly in a lot of cases is like, yeah, they're violating your patent laws, that's fine, / good. And it's like, okay, well, what do you do to enforce that? But that gets into a whole kind of different kind of forms. Does that answer your question?
Yeah.
Yeah.
So what if gradual changes were made to like an idea or an invention such that you can file like a new patent for that idea since it's still like different now?
Yeah, so for anyone who didn't hear, the question is like, what about if you then kind of iterate on a patent, come up with an idea that's kind of similar in some ways but different enough that you could potentially get away with filing it? This starts to connect to this like requirements bucket of like, what sorts of things are patentable and what are the standards the court, the first PTO and later the court are going to apply to determine whether the patent is lawful. Because if what you're doing there, if let's say separately and in parallel, you came up with an idea that serves a similar set of goals or something, but it's not incorporating into the design features of a given patent, that's completely fine. / is a feature of this system. And to the extent that some of that is facilitated by the open exchange of information, we think that that is good. Because that is, going back to this idea of like, the goal here is maximize subtle benefit. No one is taking away anything from your ability to profit from having produced the thing that you produced. If someone else is like, hey, the objectives you're trying to accomplish there, whatever, are good ones, but we come up with this like other, better way, that is, in the eyes of the US patent system, in most cases, just like the market working as intended. If in contrast, what you're talking about is like the way that you packaged it, I forget what language you used, but like iterating on the thing and coming up with something slightly different, that's a different circumstance, because then what you're doing is you're taking their invention, not an invention you separately conceived of, and like making tweaks to it, which is not allowed because it's like building on that original patent. Does that make sense? So in that context, what you need to do instead is pay that company, or try to get them to agree to license to you the initial kind of the conventional product or whatever, and then allow you to like sell your own widget that like builds on it in some way. Or alternatively, wait until that patent period expires and do that. Does that make sense? Does that answer your question?
I was wondering if there's like you decide to take that product and then you like gradually develop it without like to like basically or is it just like
Another very good question. So the question was, if you come up with a product, get it patented, and then you continue to kind of iterate on it and keep filing new patents on those new iterations of it, does that allow you to monopolize the thing in perpetuity? That is a very real question / problem that the US patent system has needed to grapple with in a number of different contexts over time. And that's been one of the major drivers when there have been major kind of developments or advancements in the standards that are applied. Stuff like that tends to be kind of the forcing mechanism for those sorts of innovations occurring. Because pharmaceutical companies, for example, do this all the time. They'll be like, here's a tweak to the formulation of this drug, or like, here's ibuprofen that's a different color now, like, new patent, please. And you're not allowed to do that because of the first requirement so there's actually a step 0 here, which is the thing has to be quote unquote patentable subject matter. We're not going to talk too much about what that means right now, but there are some things that cannot be patented. But then that, talk about it later. Assuming that the thing is patentable at all, 3 kind of major requirements need to be fulfilled. The first one is that it has to be novel. And so the example that you were asking about there, where it's like you've iterated on this thing, yeah, there might be some amount of innovation occurring there, but it's not actually an invention that's patentable in the sense that it isn't a novel new thing. Does that make sense? It's an iteration on an old thing, and therefore cannot be separately patented. Yeah.
It's not obvious for like the average person or the average person in whatever field the patent is being.
The latter, but hold on that for 1 second. We're going to talk about that. Other questions about stuff we've said so far?
So how do like all of these like big companies that have been making the same product for like decades and decades and decades continue to do so without like?
Well, you can keep producing the things, just that other people also can.
Oh, okay. But like I feel like
How do you like prove who conceived the idea?
Okay, yeah, let's pivot to talking about these requirements and how they're applied. Unless anyone has questions about, just good to you, but all that kind of points in this direction. Any other pressing views about big picture stuff in front of us? Okay, so first thing is that it needs to be novel. That is sort of, like all of these things, including that requirement that it be novel, are definitely very much subject to interpretation. And so there's a very large body of case law as well as administrative decisions that have emerged over time to help define the boundaries of what does it mean for a thing to be novel or not novel or whatever. We could talk about each of these requirements alone for hours. So instead of that, I'm going to like leave it at the novelty spectrum, and then you should be aware that like this is a thing that you will continue to like learn about more over time. Second is that it needs to be useful. Again, we won't talk about that too much. The main thing we want to talk about right now is the combination of that it has to be non-obvious and that you need to be the person who conceived of it. So non-obviousness as a requirement and the conception requirement. Conception, which gets to your question a second ago, the question was asked how you go about proving that you're the one who conceived of it. That, again, this is part of why you want to be sure if you are going to file for a given invention, especially if it's something that is something you've like chatted with other people about or whatever. You want to leave as much of a paper trail, establish as much of a paper trail of this set of stuff as possible. One of the ways that people can kind of run afoul of this requirement is like maybe somebody was the first person to file for it, but someone else then comes forward with proof that a couple of years prior to that they have like voiced this idea to that person. Stuff like that kind of gets you in trouble. It's a different situation if they were to like not have that kind of proof, right? Then you're just dealing with like, well, this person was the first person who filed it. We don't have any proof to the contrary, so like, as far as we're concerned, they did conceive of it. There are all kinds of other potential legal gray areas. One about if you're working with a group of other people on a given project and somebody doesn't directly voice that idea, but they do say stuff that ends up constituting the core of this idea, like, are you the person who conceived of it? Are they? Are both of you?